So today, I'm going to be talking about openness, innovation, exclusivity, and limits, and what comes first, the chicken or the egg. Does innovation require ownership? Our founding fathers certainly thought so. Many years ago, 224 years to be exact, our founding fathers said, well, how are we going to make this new country work? How is it going to be economically profitable? Well, they said in the Constitution, to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Now, this was 224 years ago, and our founding fathers recognized that you had a tug of war between what would be exclusive and what would be open. So now we have a patent system and a copyright system whereby you're given limited exclusivity. And what happens after that? How has it worked? After the limited exclusivity, you have complete openness. You are allowed to use that invention or that writing for whatever purpose you want. And it has worked. But there have been issues. Henry David Thoreau in Walden said, "We are all sculptors and painters, and our materials are our own flesh and blood and bones." But do we really own our flesh and blood and bones and our genes? No, we don't. Someone else does. Does anyone know who this picture represents? This is a woman named Henrietta Lacks. She died many years ago. She had gone to Johns Hopkins at the age of 30. She wasn't feeling well. Johns Hopkins evaluated her and determined that she had cervical cancer. Back in the 50s, there was no treatment. Now, when you go to the hospital, when you go to the doctor, they take blood. They may take tissue. You're giving it to them. Do you sign any documents? I was just at the doctor. I didn't sign anything. They took blood. What happened with Ms. Lacks? Well, the doctors took her blood and her tissues, and they gave them to Dr. George Gay, who proceeded to notice that her cells never died. They were immortal, endlessly replicating. Researchers had been working on this for years. Henrietta Lacks' cells, called HeLa cells, are now the basis of modern biology. They enabled everything that we know, vaccines to be tested, cells to be replicated, genes to be created. Was Henrietta Lacks' family ever compensated for the use of her blood? The answer is no. They didn't even know that the HeLa cell line had been created until the 1970s. There are 11,000 patents, 11,000 on the HeLa cell line. How much has Henrietta Lacks' family, not very wealthy, she was a poor tobacco farmer, received? The definition of openness, 0. She was never compensated. Her family was never compensated. Now, you say, well, that was the 50s. This is America. We live to litigate. What has happened since then? California treats your blood, your bones, your cells, your tissues as waste once they leave your body. This was decided in a case where John Moore, who had hairy cell leukemia, had signed some documents consenting to a certain amount of research on his cells, but certainly had never consented to someone else owning them and patenting them. So that's the HeLa cell line, $250 per vial. And this is the patent that was received by the University of California on John Moore's cells. They're called the Mo cell line. This is one of the patent claims. DNA fragments. They're claiming the entire DNA of John Moore. So he sued in state court in California saying, you can't use my private property. California said, no, you gave it away. Doesn't belong to you anymore. It belongs to us. Still the law today. No federal law on this subject. Now, there was one guy, Ted Slavin, who had hemophilia. So he had been receiving massive, through his entire life, blood donations. As a result, his blood had a huge viral load of hepatitis B. Now, this was in the 70s. But Ted's doctor said, you know, you've got something valuable in your blood. Don't just give it away. So Ted, knowing that he needed treatment, got together with many other people in similar circumstances, and they sold their blood, knowing that it had value. And Ted started a company named Essential Biologicals to do that very thing. But Ted also did something else. Ted was open. Ted gave his blood to a Nobel Prize researcher so that that researcher could develop a vaccine for hepatitis B. So he was compensated, but he also donated his blood for a great purpose. Now, what's happened since? From a legal perspective, you still don't own your blood. You still don't own your tissues. Ted Slavin was an outlier. There's a circuit court case, the 8th Circuit Court of Appeals, where Dr. Catalona, who was developing certain techniques, got permission from many people to use their blood in their research. He decided to leave his university and wanted to take his research with him. Not so fast. Even though the people who donated the blood to Dr. Catalona said, yes, we want you to continue on this promising research path, the university said, nope, it belongs to us. Court of Appeals said, yeah, we agree with the university. It belongs to them. Now, this is a patent, one of the early ones, on DNA. Yes, DNA, your gene sequence, can be patented. Indeed, Henrietta Lacks' gene sequence was disclosed by European researchers 2 weeks ago. Your gene sequence tells a lot about you medically. Now, Henrietta Lacks' family wasn't even asked if the gene sequence could be disclosed. There was a bit of a furor, and the European researchers took it down. But they had initially posted it on that newfangled thing called, the internet. So it's open. Anyone can see Ms. Lacks' sequence right now. But that's the way it is. Now, this goes into the next question. Are there innovations that shouldn't be privately owned? Should someone be able to own your gene sequence? Well, this case is actually before the Supreme Court. Are human genes patentable? April 15th is the oral argument. How did this come up? The ACLU sued Myriad, which is the only provider of the breast cancer test, because they said the Constitution says products of nature aren't patentable. So why should human genes, which are products of nature, we produce them, you, me, why should they be patentable? Well, it's been 2 decades since human genes could be patented. There are about roughly 2,400 patents on human genes. 20% of the human genome has been patented. So if the Supreme Court says no, human genes are no longer patentable, it's going to have an effect. They're looking at whether the genes in your body are markedly different from the genes outside your body. And we'll see what the Supreme Court says about it. And this goes right into, does innovation require ownership? Do we really need patents? Certainly, there can be a balance between having something patented and having something completely open. Not everything needs to be patented for a successful marketing strategy. Not everything needs to be protected. You can have openness. Open source is openness. Both Google and Twitter now have open source policies where they're licensing their patents for free. and only using them for defensive purposes. This is a new innovation. So my time is up. I hope you've enjoyed what I've had to say. And if you have any questions, I'm on the internet. Thank you.